I'm sure we will get more people as we go on. Today is very exciting. I'm really interested in this topic, and I hope you are. Well, I guess you are, or you wouldn't sign up. But Intellectual Property 101 for entrepreneurs. As a SCORE mentor, we get lots of questions about that. We are honored to have Dr. Ralph Warmack with us today, who is a registered patent agent. So this is the place to come to get your questions answered about intellectual property and patents. Speaking of questions, I'm sure I'll say this again, but I'd like you to put your questions in the Q&A, if you would, please, and not in the chat. The chat gets kind of clogged up with a lot of other things, and the Q&A is a nice, easy way for us to monitor that. Dr. Warmack will be answering questions at the end of our session. So before we get started, I need to do a little business. I need to tell you a little bit about SCORE. SCORE is a nationwide nonprofit organization, and we are an independent resource partner of the SBA, or Small Business Administration. SCORE provides small businesses with free, always free, never a fee, confidential business mentoring, both in person and online. Actually, most of it these days is still online, but it could also be in person. Our chapter, which is the Minnesota chapter, serves Manatee and Sarasota counties, and we have nearly 90 volunteers who are ready to help you with your business questions and to advance you to that next level. Our chapter, we're very proud to say, was recently recognized as a district chapter of the year. And SCORE was founded more than 50 years ago and has, they say, assisted nearly 11 million clients. So in the business process, where can we help you? Well, actually, the whole process. We can help you if you woke up this morning and thought you might have a great idea for a business. Well, contact us. We'll work through and see if that's really a viable idea. Or you've opened a business and now you realize that you don't know everything about everything and you need a little help. We can help you with that. Or you are in business and you realize you want to grow. Maybe you want to have a second venue or start a franchise. We can help you with that. Or lastly, if you're thinking about selling or closing your business, or the alternative, buying a business, contact us. We don't want you to leave money on the table or pay too much. So contact us and we can help you with that as well. We encourage you to visit our website, which is score.org/Minnesota. There you can request a mentor. It's a nice, easy button for you to click on. You can look at the mentor profiles and see who you'd like to work with. You can actually request a mentor, and if they're available and it's a match, you can get them. You can check for our local workshops. We have webinars every single week at noon on Wednesday. Count on it, on a variety of topics that you need for your business. So click on local workshops and sign up for any one of our upcoming workshops. Or you can do a search for recorded information or templates that are available on our website. Lastly, I'd like to thank our sponsors and community partners. You'll notice that many of our sponsors are banks. And it is true that if you walk into a bank with a SCORE mentor on your arm or in your pocket, if they fit there, they will listen to you a lot more than if you just walk in by yourself, because they know that there's a whole team behind you. So keep that in mind when you're thinking about applying for a mentor. So without further ado, I am actually going to stop sharing my screen so that our presenter, Dr. Warmack, can share his screen and get started with a presentation. So take it away, Dr. Warmack.
Thank you, Diane. Can you hear me okay?
I can hear you perfectly fine.
Okay.
Absolutely.
Let me put this in presentation mode.
Wonderful.
Okay. So thank you, Diane, and welcome to everybody. Good afternoon. I also want to thank Diane's chapter, the Minnesota chapter, for organizing and presenting this presentation. I hope it's useful to you. And so let's get started. So what is intellectual property? Well, it refers to IP refers to your creations and your ownership, especially your ownership of your ideas and designs. So there are four aspects that I want to discuss today of intellectual property: copyrights, trademarks, patents, and trade secrets. And I'll go through each of those individually. So patents and trademarks come from the US Constitution, which has a provision that says that authors and inventors have the exclusive right, may have the exclusive right, if they're granted a trademark or a patent, to their respective writings and discoveries. And the word authors applies to not only writers, but artists and artisans and designers and the like. So we'll talk a little bit about that in a moment. These are the four aspects that we're going to cover today: trademarks, copyrights, patents, and trade secrets. And I'll go through each individually. This shows basically what they apply to, and we'll be talking about that in each of the sections. But I want to point out that IP, intellectual property infringement, in other words, if somebody tries to steal your, with one exception, which I'll mention at the end, if somebody tries to steal your idea or your patent, that is not a criminal offense. And so it is a civil offense, and it's up to you as the IP owner for a trademark, a copyright, or patent. It's up to you to police and enforce their rights. You can't call the guys with the guns and the blue lights to come help you, because if somebody steals it, it's your responsibility to enforce your right. So let's talk about copyright and their basics. Copyrights are for original works of art. And as I mentioned before, it's for authors and designers and musicians and artisans. So all of these aspects, all these parts, literary, dramatic, movies, art, they're all covered under the copyright laws. Copyrights cover the expression, in other words, the written work or the physical work, not the idea itself. So it's not your idea that you're going to be copywriting. It's what you write down, your book, your materials, your software. And in fact, as you'll see in a moment, even PowerPoint presentations like this one can be copyrighted. Copyrights do not cover words themselves or phrases. They don't cover logos or symbols. We'll talk about that in trademarks. But they cover complete works of art, whether it's written, literary, or drama, or music, movies, and art. Under common law copyrights, a copyright can be added to a creation and need not be registered. I want to repeat that. You don't have to register your copyright. We'll talk about why you might want to do that, but you don't have to. You can mark your computer code, your literature, your PowerPoint presentation, your website, and you can do all that with the word copyright or the circle C, along with the years of publication and name of a company, name of your company. For example, on this PowerPoint presentation, as I showed in the first slide, I put copyright, circle C, my name, and then the years that I have presented this from 2019 through this year. Sometimes you see the words all rights reserved, especially in book covers, and that indicates that the content cannot be copied freely, but you have to ask permission. But it is not required. In other words, you don't have to have permission. I'll talk about that in a minute. And it no longer has any legal effect. So when you see the all rights reserved, you need to take note of that, but it is not a legal requirement. In order to sue an offender, in other words, if you write a book or do a painting or do something, even a PowerPoint presentation, and somebody copies it and uses it for commercial purposes, you can sue them, but only if your copyright is registered. And you can register your copyright at the Copyright Office in the Library of Congress. There are online fees to do that, and it's for a single author, one work, not for hire. In other words, you're doing it for yourself, not for your company. It's $45. A standard application, which may include a for hire work for a company, is $65. And the copyright term is your life, the length of your life, plus 70 years. Now, work for hire rules and the term are different. So when you register your copyright, you need to also take a note of your employment or work agreement. You may work for a company that says that your copyright, that your work is covered by their copyright, not yours. For example, when I was with IBM as an active employee, anything that I created had Circle C IBM, not my name. So it was copyrighted by IBM, not by me. And that applies to most major companies and certainly even some small companies. So what does a copyright look like? Well, as I mentioned a couple of times, it can apply to articles, that is newspapers. It can apply to photos and paintings. It can even apply to jewelry. And it can obviously can apply to books. I'm a fan of the Bosch series. So you'll see here that it says copyright by Hieronymus Incorporated, which is Michael Connelly's company. So he copyrighted it under the name of his company. And also the cover is copyrighted, as you'll see, by the publisher. So you can see multiple copyrights oftentimes in books and in newspapers and in other literature. If you're going to copy somebody's work, especially a book, for example, or a PowerPoint presentation or an article you see in a newspaper, you can use it for yourself without any issues. You don't need permission. But if you're going to use it in a commercial application or in a presentation or in a school setting where you're doing it actually for a classroom setting, you need to attribute where you got that literature or where you got that quote. And so you need to identify the source, the date, and the copyright, and possibly if it's reprinted with permission. So if you actually ask for permission to copy this article, then you need to say reprinted with permission. So don't forget to attribute where you got anything that you want to copy that is copyrighted or identified as copyrighted, whether it's, and that, by the way, that's whether it is registered or not. Let's move on to trademarks, the second aspect of intellectual property. Trademarks, as you may already know, protect words, phrases, symbols, designs, but they identify the source of the goods or services. So they don't identify necessarily the product, they identify the source of that product. A trade name and a logo must be unique, and I'll tell you what that means in a second here. Trademarks and logos do not need to be identical to be challenged. So you can have a trademark, and I'll tell the next bullet talks about that. You can have a trademark, or you can have a logo or a name that looks like somebody else's, and it may or may not be subject to being challenged. The trademarks and the logos covered by a trademark are judged by the quote likelihood of confusion analysis. And what that means is, let me give you a couple of examples. You're all familiar with Radio Shack, or you were when it was in business, and Shake Shack. Those both have similar names, but they're not likely to be confused. Radio Shack sells or did sell electronic items. Shake Shack sells a hamburger. So those two names could be independently trademarked without any likelihood of confusion. However, I dealt in past times with a couple of companies, one called Biomagnetics USA and another called Biomagnetic USA. And one tried to trademark and the other tried to trademark, and they were denied that because the names are similar. Not only the names similar, but they're in the same business. And so that's what we mean by a likelihood of confusion. So if you're in the same business, you want to make sure that the name of your product, the name of the source of your product and service is different than somebody else's. So what you have to consider when you're thinking about a trademark name is whether it's strong or weak. And if you look at the top part of this chart here, you'll see that it goes from left to right, strongest to weakest. And so a strong example of a trademark would be something like Google, Exxon, Clorox. Those names do not necessarily identify the exact product or service that they're applied to. Similarly, another stronger would be Apple, Amazon, Dove. Now, those may be always thought of. You think of those names as being applied to a product or service, but in fact, they don't in and of themselves identify that product or service. As we get further to the right, we see things like Bank of America, Best Buy, British Airways. Those are considered weaker trademarks because they identify the product as the name of the product is buried inside of it. And if you go all the way to the right, you see that something like bicycle, serial, email, table, none of those generic names would be eligible to be trademarked. So you want to consider a name that may be totally made up, which is what Google and Exxon and Clorox, those are totally made up names that apply to and are now marketed as a source of a product or service. The other thing you want to consider is that there are some less common types of trademarks. Colors, for example, the UPS brown, everybody's familiar with that. Tiffany blue, Coca-Cola red, everybody's familiar with that. Shapes, the bottle, the little fish, goldfish, and even the shape of a telephone, whether it be Apple or Android, can be trademarked. So that shape, and we'll talk about the how it might be patented also, but that shape can be trademarked. Sounds and scents can also be trademarked and have been trademarked. For example, one of the things I like to note here is that the MGM's Lion Roar was trademarked years and years ago. So you want to make sure that your trade name and logo are unique and strong. And if you decide to register your trademark, you're going to do it at the USPTO, the U.S. Patent and Trademark Office, which is located in the Department of Commerce. And that's the link for it. But you also, in Florida, you want to check the fictitious name site at sunbiz.org, because a fictitious name may not be trademarked through the trademark office, but may be being used commonly in the state of Florida. And you want to avoid having a common name with them, because the trademark office, if you went to them and tried to register your trademark, is going to be looking at those fictitious names and say, no, you can't use that because somebody else is using it. So one thing to always remember is that you can apply the superscript TM or the superscript SM, and TM stands for trademark, SM stands for service mark. You can apply that to any of your business activities without registering your trademark. And the logo of your business, you can apply that also. And you're doing that under, as I talked about, under copyrights, you're doing that under copyright laws. However, let me go to the next chart. You're not required, as I said, you're not required to register your trademark, but if you want to be able to take somebody to court over the use of your name, you need to have a registered trademark through the USPTO. So it requires, in order to register your trademark with the USPTO, you're required to be doing business in interstate commerce, that is outside of the state of Florida. And if you're doing a web business, oftentimes that's considered interstate commerce. The term of a registered trademark is 10 years, and it's a renewable in 10 more years. The filing fee is $750 per class. And what is a class? It's a type of good or service. So it might be a kitchen appliance, or it might be a tool. And for each of the classes that you declare that trademark for, you're going to be required to pay $750. Legal fees, if you use a trademark attorney, are going to be somewhere $1,000 or more. And since the filing and renewals are fairly complicated, I strongly recommend that you seek a trademark attorney for help in registering and following up on your trademark. It's not easy. You can do it yourself, but it's not straightforward. It's fairly complicated. Okay, so let's move on to the third part of intellectual property, patents. And that, as I mentioned at the beginning, it's covered by the Constitution. It was put in the Constitution to prevent others from making, using, selling, or selling, offering for sale your invention. Patents protect your invention from honest and reputable folks, not from dishonest and unreputable folks. So even if you have a patent and somebody comes and copies your invention, what are you going to do to them? And let me just say that the first thing you're probably going to try to do is send them a cease and desist order. Then you're going to hire an attorney, and you're probably going to have to take them to court. So how much would that cost? Well, on average, fighting a patent infringement suit in court is usually somewhere between $300,000 and $1 million for the average inventor. And it's very, very costly. So a patent doesn't necessarily protect you from dishonest and disreputable folks. It does protect you from honest and reputable folks, and that's really what you're seeking. Patents, applications for patent require certain things to happen. First of all, you cannot patent an idea. It has to be something that you have actually invented. Discoveries, scientific theories, math methods, mental acts, game playing schemes, computer programs, none of those are eligible to be patented. So you have to have a real invention, if you will, a physical invention or a describable invention to be able to be patented, to apply for a patent. And there are three types of patents. There's a plant patent, a design patent, and a utility patent. Let's go through each of those briefly. Let's start with the plant patent. That's easy because most people don't that are outside the academic world don't apply for plant patents. So plant patents are granted for the asexual reproduction or plant parts. They protect only a single plant, not the technology used to produce it. And the requirements are different and less stringent than design and utility patents, which I'll discuss in a second. The plant patent is good for 20 years from the earliest filing. And while I have those words earliest filing, let me mention that 10 years ago, if you and I invented the same thing, but I invented it first, when I go to the USPTO, they would grant me the patent, not you, because I was the first, but I had to document it. If I documented inventing it first, then they would grant me the patent and not you. However, 10 years ago, it changed to a different scheme, a different regime. And now it's the filing, first to file. So if you and I invent something that's similar or identical, and you file your application for a patent first, then you're going to win. You're going to win the race. Design patents. Design patents cover a lot of different aspects of design. New and original ornamental design for an article of manufacture. So I mentioned before that a Apple phone or a Android phone, the shape of it can be patented, and most all of them, virtually all of them, are patented, by the way. They protect only the appearance, not the article itself. So when you see that a Apple phone, an iPhone, has a patent on the design, that doesn't cover the phone itself. It covers the design of that phone, the shape of it. The application for a design patent only requires a drawing or multiple drawings and a single claim. And I'll tell you why the single claim is important here in a second. 14, and it's good for 14 years from the earliest filing. Again, it's the first to file that wins the suit here, wins the patent. Claims are the most important part of a utility patent, and I'll mention that again when I go to the next slide. So having to write only a single claim, which is pretty simple, and the claim usually for a design patent just says, see the attached application, the attached drawing for this application. So it's pretty simple to do that, but it does require fairly sophisticated drawings, which you generally want to get done through a patent creator of drawings, somebody who does drawings for a living for patents. So let's finally move on to utility patent. That's the most common that you're probably familiar with. And the utility patent covers a process, a machine, an item of manufacture, composition of matter, or importantly, a new or unuseful improvement of a process, machine, or an article of manufacture. So if you've made a new and useful improvement, then that is potentially eligible for a utility patent. But patent eligibility for a utility patent requires that the three things have to be in place. One is that your invention, has to be useful, it has to be novel, and it has to be non-obvious. Usefulness is generally a low bar to go over. Generally, most people that invent something find that it can demonstrate that is a useful invention. Novelty is a different story. Novelty means that it can't have things in the open market that are identical or very, very similar to it. So your novelty has to be that it's really something new and obviously useful. Non-obvious is the highest bar to get over. Non-obvious means that somebody, quote, schooled in the art, that is somebody familiar with this area of technology or business. Somebody schooled in the art would be able to look at your invention and say, oh, that's similar to this patent, or that's similar to this device being sold today. It's obvious to me, and somebody schooled in the art is going to be able to identify something that where the prior art is readily available to disclaim that your invention. And the utility patent is good for 20 years from the earliest filing. Again, I'll point out first to file. And there are some extensions and contractions on a utility patent, and that has to do with when it's filed, how long it takes, and the patent office can extend or retract the filing date. So some people want to know, are computer programs and business methods eligible for patents? The answer to that is no. Computer programs and business methods are not patent eligible. And courts and the USPTO have ruled that business methods not associated with the underlying technology are not patent eligible. So for example, if you have a business method and you want to patent it, you have to show how it runs, where it runs on computer hardware and peripherals, and how that methodology, that software methodology, works on all this computer. It has to be demonstratable on an actual computer hardware method. Inventions which include a business method and which are carried out on a computer program may be patent eligible. And I want to stress may. A lot of them are rejected these days, but some of them are eligible to be patented as a utility patent. When you file for a utility patent, your application, whether it's granted or not, is automatically published after 18 months from filing. So the quote, the cat is out of the bag, is there in 18 months, whether your patent is granted or not, or whether you've actually gotten a USPTO answer, office action. I'll talk about that in a second. And I just want to point that out. Some people list all their patents, and they'll list the patents, and then they'll in there will be some of the patents that are actually applications that have been published. So when you pull it up on online and you look at a patent, you want to make sure you're looking at the actual, when it says granted, it's going to have a granted date, versus those that are patent applications. And they clearly say at the top of the patent that's published, this is a patent application. It doesn't say this is not a patent, but it is not a patent. The filing and prosecution of a quote regular non-provisional patent application ranges from anywhere from $5,000 to $15,000. So it's a fairly wide range to cover if you're going to use legal counsel, patent agent, or a patent attorney to file and prosecute your patent. The first USPTO response, which they call an office action to your patent application, will generally arrive in a year or two, sometimes shorter, sometimes longer. And the first answer is always no, it's not patentable. So they're going to require you and your attorney or patent agent to go through an argument list of why this is true. And they're going to identify some language that they find objectionable and so forth. So the first office action is always going to be responded to by you or your attorney. And it may take 3 to 5 years to fully prosecute a patent application. So it's not an easy process. There's another thing that you need to be aware of, and that's a provisional patent application, which applies to and is useful for many individual individual inventors. It can't be used for design patents, so you can only use it for a utility patent, and you can file it yourself, and that's called pro se. File a pro se online at fairly low cost. But if you file a provisional application, beware that it is, quote, not a patent. It's not examined. They put it in a drawer, literally either an electronic or a physical filing drawer, depending on how you filed it, electronically or in writing. And it's valid. The provisional patent application is valid for only 12 months. And what that does is it gives you a year to decide whether to spend the time and the money on a quote regular non-provisional application. So this is useful in being able to allow you to have some protection at first, but beware also that your provisional application must define and describe your invention totally. You can't come back with a non-provisional application a year or less later and have new features on it. They won't allow your priority date to apply then that you had with your provisional application. So your provisional application does a couple of things for you. It provides a priority date, so it gives you a first to file date and allows you to use the words patent pending. And so it does that for you. It allows you to use the words patent pending and gives you a priority date. But again, I want to point out that if you file a later non-provisional application, what's called a regular patent application, and you want to declare that first to file date that you had in your provisional application, it's going to be allowed provided you fully described your invention in the provisional application. And that application must include the specification and drawings, a cover sheet and declaration. There's a fairly reasonable $64 fee for filing it. And that's for what's called a micro entity, which generally speaking is going to be people that are operating individually, not in a company environment, and don't have a lot of money. But the advantage, one of the advantages in the provisional patent application is you don't have to include your claims. So you don't have to, they're not required. And in a non-provisional regular patent application, the claims are the most important part of the application itself. So the claims are not required in the provisional, but are definitely not only required, but they are the essence of a patent, and they're the essence of the non-provisional regular patent application. Let's finally move on to trade secrets. I think most of you may be familiar with what a trade secret is, but it's information which you keep or your company keeps secret. And to be considered a trade secret, it must be information which concerns your commercial or operating circumstances, and which, if they were disclosed, would harm you or your company. And anyone, contrary to what I said about the other parts of intellectual property, anyone who gains access or reveals a trade secret without authorization can be subject to a penalty, fine, or imprisonment. There's US law that applies to trade secrets. That, as I said before, the other parts of intellectual property, you have to police yourself, but that's not true with a trade secret. With a trade secret, you can apply to the court for relief and get a penalty or fine or imprisonment against the person who stole your secret. What are examples of trade secrets? Well, Kentucky Fried Chicken's secret blend, and Coca-Cola's recipe for Coke, Google search algorithm, the special sauce for a Big Mac. And if you have a company or yourself have a client list, that can be considered a trade secret. So companies that I've worked for in my past always made sure that their employees knew that a client list is company confidential and cannot be divulged to other companies or certainly to competitors. That's not to say that your competitor won't try to find out who your clients are. So kind of in summary, again, we talked about trademarks, copyrights, patents, and trade secrets, what they cover, and they're critical to letting you invent and letting you innovate your business and your startup or existing business. If you want to learn more or find out what you need to know, there's a quiz that you can take on the USPTO website. And by taking this quiz, you can measure your own awareness and increase your awareness by the answers it gives and by the questions it asks you. So if you're really interested in the subject, I highly encourage you to go to this website and take this quiz and learn more about IP. So with that, Diane, what questions do we have? And as I told Diane yesterday, I will do my best to answer your question, and if you have any, and if I don't know the answer, I'll make one up.
We have lots of questions. One question is, why can't we see Ralph? We want to see your face when you're talking to us. Could you turn on your video?
Okay, if I can get to it.
Yeah, if you can, while I'm looking at your questions. So we have a lot of questions for you. The first one, I'm a little confused by it, but it was posted by Anonymous, so I can't ask them live about it. But it sounds like whether or not an LLC was formed, we're going to have investors and future partners added along the way. Would it be advantageous to file for an IP rights with the LLC name versus filing with our personal name? Does that make sense to you, Ralph? Well,
the LLC name doesn't have anything to do necessarily with trademarks or copyrights. So unless you're a very, very big company, I would advise you not to even think in that direction. My advice always with an LLC is to make sure that you do it through in Florida, through the sunbiz.org website, and make sure you also check the fictitious names. So you want to choose a name. Generally speaking, my advice is choose a name that is your initials or Smith Enterprises or something business related. Has nothing to, your LLC name has nothing to do with your trade name.
Good. When Don wants to know, when seeking permission for use of work with multiple copyrights, must you have permission from all of the holders, or is permission from any of them sufficient?
Well, I would say in general that if you get permission from the author of any article or book, you're covered. As I showed you on that one book copyright I put on there, the cover was copyrighted by the publisher. The book itself was copyrighted by the author, his company. So if you were going to copy a page in that book and use it as in a presentation mode, and you were concerned about getting permission, then I would contact the author and try to get permission from the author.
Paula writes, what if you use a name as an acronym that is your business name of someone else? What if you use your name as an acronym? But I guess it's a business name of someone else is what she's asking.
I would personally avoid that.
Right.
Again, people, if you're using a name that's similar to somebody else, they can come, they're going to come after you potentially and say, quit using my name. So to make it easy, just spell it backwards. There used to be, I can't remember that I've heard it recently, but on the radio, there used to be some snoring device that was sold and advertised on the air, and it was called Zipa, and it was Happy Z spelled backwards. And that's an example of somebody that took a name that it was unlikely that they would ever find somebody that spelled Happy Z backwards as a trade name, and that's what they were using as a trade name. So I would strongly suggest you choose something that is so far out that nobody else, you're not going to be competing with anybody else.
A famous example of that is Oprah, right? She uses Harpo, which is the backward spelling of her name.
Yes. Even though there was a Harpo Marx, but nobody's going to confuse her company with that.
When you say low protection and enforceability for descriptive marks, does that mean that Bank of America, Best Buy, British Airways, etc., in their starting days when they were small, would be more likely to prevent other brands in the US or other countries from entering with the same name?
Well, your question implies you're asking the right question, because when you said they were small, as they grew, and I can't really speak to when they were really, really small, but as they grew, you certainly, if you use Bank of America today, I can guarantee you they have enough money and enough attorneys that they're going to come after you. So it depends a lot on the size of the company and their resources.
All right. Anonymous is asking many questions. I've heard that using TM for a service business encompasses more protections than SM, and that TM is more globally understood / prevents people from coming in to use the name versus if they see SM. True or not true?
Well, I agree that TM is probably more recognizable than SM, but I see them both, and I know that they have equal authority through the USPTO. I think you can use either one.
Oh, right. Again, Anonymous, I thought the filing fee per class was a few hundred, and that when we file, we'd need to renew after 5 years. Did the USPTO make any big or small changes during the pandemic time from what was previously?
The numbers that I quoted you, $750 per class, is what's shown on the current USPTO website. So I would encourage you to go to the USPTO, and somewhere in there, you're going to find a list of fees. Just search for fees when you're in the USPTO website, and it'll list you. It's got several pages of fees, and you can see what they are. But the $750 that I quoted, I recently, within the past couple of days, looked, and that was the number that I saw on their website.
So current information, good to know. Anonymous is also asking, Could you kindly share examples of why filing one's own trademark is not straightforward? What pitfalls might someone or will someone definitely encounter in the process? And if we're severely low in budget, have over a dozen trademarks we want to formally file, generally speaking, would hiring an attorney for one trademark application allow us to largely comprehend how to do it and file the other trademarks on our own?
Well, you might be able to. I'm not sure. If you really want to file a number of trademarks, I'd go negotiate with an attorney, a trademark attorney, and see what he or she might want to charge you for multiple trademarks. The complications and the issues come in, as I said, the likelihood of confusion. I'm not a trademark attorney, and so I'm a patent agent, not a trademark attorney. But the trademarks that I've dealt with clients over the years with, and they asked me questions about it, and what I saw, their response from the USPTO has mainly been on that confusion of the likelihood of confusion. And so that has to be argued, and you can try to do it yourself. And some people are very successful at doing that. So it depends how comfortable you feel with making those arguments. The other aspect is the renewals and the time frame, and when you have to file for renewals with a trademark can get very, very tricky. And so I would always advise using somebody that knows how to do that, that makes sure you're protected into the future. It's not just today's application, it's the ongoing trademark process that can get somewhat complicated.
Here's a question for me. When can you have access to the presentation after the webinar? Once it's processed, and it takes a little while to do that, and we upload it to our YouTube channel, you will get the link, and that link typically is emailed to you tomorrow, along with the wonderful slides that Dr. Wormack has been using. So look for those in your email. All right. Anonymous, what was the range in reasonable price one might expect to pay a trademark attorney, and what qualities or qualifications or specific experience would clue us to someone who truly knows the ins and outs of conducting thorough trademark searching through across all countries if we wish to expand globally? I have concern that depending on the attorney I'd hire and the sophistication of their international trademark search software, that I'd run into problems if they have a low quality product or search process.
I can't speak for international trademarks. I can only speak for what I know about American rules and laws. But my suggestion to you to find an attorney, whether it's a business attorney or a trademark attorney, is go to your SCORE chapter and ask the SCORE chapter, who generally has resources and lists of qualified attorneys and business experts that they can refer you to.
And you can get those just by applying for a mentor. You don't necessarily have to get a mentor. We might send you that. There's a good chance we would send you that if that's your only question. Don is asking, is a quote claim the assertion of usefulness, novelty, and non-obviousness?
A claim does not cover novelty. It peripherally covers usefulness, but more importantly, it covers the exact methodology and the exact implementation of your invention. It's going to talk about, let me just say, the nuts and bolts of how your invention goes together. And so that's what the claims have to do. And generally speaking, a good patent application is going to have anywhere from, let me just say, off the top of my head, 5 to 25 claims. And let me, while we're on that subject, let me make a comment about that. I had in one of my charts, and I didn't emphasize it perhaps enough, that the first to market generally trumps first to file. So I mentioned that the new scheme 10 years ago, started a scheme of first to file wins the race to get a patent application filed and potentially granted. But first to market generally trumps first to file. And let me give you an example of why I find that to be true. Everybody, or most people, are familiar with the Ring doorbell, the video doorbell. That was invented by a guy named Jimmy Siminoff. And Jimmy Siminoff marketed the heck out of that, sold a lot, and eventually sold his company a couple of years ago to Amazon for almost $1 billion. That's billion with a B, almost $1 billion. And so the thing I want to point out is Jimmy Siminoff never had and doesn't have a patent on his Ring doorbell. But why was he so successful? Because he was first to market.
Good point. What are the current timelines to hear back from these government offices on the status of our applications? What is the soonest we'd reach the finish line of receiving IP rights? And lastly, approximately what % of the time would you say copyright, trademark, and patent applications are accepted on the first go round? And then for those rejected, approximately what % are accepted on the second or third go round?
If you Google that, you'll find the answers to most of those questions. And I don't have them off the top of my head. I will just say that generally speaking, the applications that are filed, when they're first filed, they're going to get a first action office notice, unless, well, the first office action notice may come very quickly. If you've not paid the right fees or you're not submitted the right form, they're going to send you a letter right away and say, you're missing all these items. You got to submit them for your application to even be accepted. The real, so-called real office action, first office action, is going to come anywhere from, I would say, 6 months to a year later. And as I mentioned previously, what they're going to do is they're going to force you and your attorney or your legal counsel to justify the claims that you've made in your patent application, regular patent application. And again, I'm digressing here a bit, but I want to point out the provisional patent application has no claims and is never examined. So you're not going to get any response other than a confirmation number on a provisional patent application. So for a regular patent application, non-provisional regular patent application, I would say it's probably anywhere from 3 to 12 months, 6 to 12 months that you're going to get the first office action. And the latest data that I remember looking at was probably a year ago. And I would say that only, I don't know, a few percent, let me just guess it, less than 25% of all patent applications are going to be granted the first time around. By first time, I mean after the first or second or third office action. Almost none, virtually zero, are going to be granted after the very first office action. The first office action is almost never going to come back and say granted. And it can take some time. During the COVID exercise, during the pandemic, the office actions came very slow and very long in coming. And so it was really a delayed process. I worked on one last year that was probably in going on for a couple of years. And it finally got granted after justifying and changing some language. It got done fairly quickly after that.
Good. Speaking of provisional patents, if no one checks the provisional patent, then couldn't someone file a non-provisional patent for the same thing during those 12 months?
Well, yes, they could. But once you file your provisional and then you file your non-provisional within that 12-month period, you're going to have a first to file date, provided your non-provisional application is describing the same invention that your provisional did. So you're going to have the first to file, and you can beat out that person that filed later.
Good. You referred to a website for the quiz, but that wasn't on your slide. What is the address for the website?
Use that uspto.gov and just do a search on the quiz, and I think it'll come up for you.
Great. Oh, that's good. All right. Ellen is asking if you could talk a little bit about fair use.
Fair use?
Yeah.
I'm not sure I can. I'll try to make up an answer, but fair. That's a legal term that I've heard, but I'm not a lawyer, so I can't really tell you exactly how it applies. But I assume that it means that things that are in the open space, in the software world, we talk about open code. It's covered by licenses, but that's the general fair use license.
Okay. Anonymous.
I assume that applies to some of the other aspects of intellectual property.
Okay. Anonymous is saying if we do a cease and desist and the offending company continues use of a copyright or trademark, what is the range in cost to sue them in court for these too? And can we do that pro se, or could I use university students if I can't afford the tens or hundreds of thousands in legal fees to enforce my copyright and trademark?
Again, I'm not an attorney, so I can't answer definitively, but I would say it depends on whether the court would permit you to argue pro se in front of them. Number one, and number two, whether you have the resources to do it, whether it's law students or who else. I'm not sure. You can try to do it, but generally speaking, if you're a small company and somebody's stolen your invention, then it depends on who they are. If it's in the United States, you have a much better chance. If it's somebody making your product and knocking it off in China, you probably are not going to get a lot of help except through the FTC. The Federal Trade Commission can stop them from importing a product that infringes on a patent, but you'd have to have a demonstrable granted patent for them to take any action on that. And again, the cases that I've seen usually involved an attorney talking to the FTC.
I think on the same note, is the USPTO patent worldwide or just in the US?
Just in the US.
Right.
You have to apply, if you have a patent in the US, it doesn't apply to anywhere but the US. And you have to, if you want that, actually it could be the same identical invention. If you want a patent, for example, in Canada or Europe, you have to apply separately for that. I have a number. I have a number of patents that are actually, they're not mine, but I'm the inventor, but they were in the companies that I worked for, and that company decided they wanted them in Canada or Japan or other places. So there are multiple patents that cover the same invention, but they're in different localities.
And you'd probably have to do that in each country.
Yes. Well, not necessarily. In Europe, there's a European organization you can work through. You have to identify the country, but it helps you exercise that route a lot easier.
Oh, good to know. What if I go to a manufacturer and our secret sauce is in the construction of the item?
My advice to clients, like the question you're answering, is always do your homework, do your due diligence on that manufacturer. As I mentioned during the discussion of patents, your patent protects you against honest, reputable people. If you're dealing with an honest, reputable manufacturer, and he or she says they won't copy or they won't divulge anything, and they'll agree to that, especially in writing, then I'd say, okay, go ahead, but make sure you do your due diligence. If you're trying to do it through a manufacturer that's overseas, especially in China, I would be very leery of that, because they're not going to they're not going to play by the same rules you're playing by. So
Mhm.
be very, very cautious with who you're using to manufacture or even to prototype your invention, and make sure that you are comfortable. And by comfortable, I mean probably sitting down face to face with them and making sure you say these are reasonable people and they're very honest about it. Some people ask me about an NDA, a non-disclosure agreement. And you can go to your manufacturer or your prototype manufacturer and say, I've got a device here and I want you to sign an NDA. And the smaller people might be willing to do that, but a larger manufacturer is probably not going to do it. In fact, larger companies are going to say, no, I won't sign yours, but here I've got another NDA that I will sign. And you can imagine that that NDA covers them more than it covers you. But
What?
but generally they're going to make sure that you agree to use their NDA, not yours.
Uh-huh. Always a good suggestion. Use yours, not theirs. Okay, as a provisional patent, is a provisional patent available for both design patents and utility patents?
No, only for utility.
Okay.
Doesn't apply to design at all.
Paula is asking a follow-up. But what if their spelling of your name is the acronym? Remember,
There's,
she had asked a
yeah.
question earlier. Mhm.
If their spelling of your name,
And-
that's kind of hard to answer without actually looking. If you want to send me an email,
Right.
I'd be happy to try to answer that, but without actually seeing what you're talking about, I'm not sure I can say that.
Yeah, Paula, why don't you follow up with Dr. Warmack? You can see on the screen his email address. That would be,
Yeah.
That's why he put it there as follow-up questions. If you don't get your question answered or you think about one later, he'll be happy to answer them. Since you mentioned it is so expensive to defend a patent, like 30,000 K, would you only recommend to file if profits would be 10 times that? Based on your experience, what is a good rule of thumb for when you should file?
Again, my recommendation is to get to market first. First of all, if you have an invention, build prototypes. Take it to a few of your friends, people that you know are going to respect your privacy. In other words, your invention disclosure. Check it out. Make sure it's sellable first. You can file a provisional application for almost, fairly easily. So I would advise you to go ahead and, if you're worried about divulging your invention, divulging the disclosure, then go ahead and file a provisional patent application. You can use the words patent pending. That helps. It scares off, certainly it scares off any honest people from copying your invention. But make sure it's marketable before you go to the expense of filing a non-provisional regular patent application. Because what you don't want to do is just get a piece of paper you hang on the wall. That's not going to give you anything. And I always ask inventors that come to me for help, what's your objective in this invention? What do you want out of it? And sometimes they think about it and they say money. And I said, exactly. That's what you want out of your invention. You want revenue. And without that revenue, it doesn't matter. That piece of paper on the wall is not going to do you any good.
Is it possible to sell my product internationally without the international patents?
I'm sorry, say that question again, Diane.
Is it possible to sell my product internationally, but I don't have international?
Oh, yes. Yes, absolutely.
Yeah.
Absolutely. Yep. Yep.
When the initial patent expires, does it become open to anyone, or
Yes.
can you renew it?
No, not renewable. Good for 20 years. And then that what's covered in the US Constitution was giving you an exclusivity period. And that exclusivity period for a utility patent is 20 years. But once that exclusivity patent is gone, then anybody can copy it. For example, with drugs, a lot of drugs are patented, as you probably know. And when does a generic generic drug come on the market? Well, after that patent is expired.
Okay, let's see. I've got a long one here. If there are a few people calling themselves a certain kind of hairstylist, when you search online, a total of 4 pages of Google results, and I call myself the type of hairstylist, is there probably a good chance that differentiating myself as the before the type of practitioner naming will result in approval when the USPTO does an examination? It's a new wave of trying to differentiate, hence why there are only 4 to 6 people who have begun calling themselves this type of hairstylist the last couple of years. Only one has the same specialist title on LinkedIn, and in the other few persons' bios. No one has incorporated this name nor trademarked, nor any application pending for this on TESS. When I did many search permutations of the name with or without the, just thought the denotes a specialness quality that would earn the trademark potentially. Any thoughts on this?
From my experience with the Patent and Trademark Office, the answer to that is no. A word like the is not gonna make any difference.
Right. It's a pretty common word.
Right. Again, my recommendation when choosing a trade name is, call yourself something other than a hairstylist. Pick a name, pick a strange name. Spell something backwards. Spell hairstylist backwards. If you got to make it really unique in order to be able to be not only trademarked, and again, you could use the current the hairstylist with a TM. That's common law. Now somebody may object to that, but you can use that, but it's not registered. So if you want to register it, you need to pick something that's really robust and different and strong.
So could Ralph provide a general range of how much attorneys in Florida charge to file a trademark application or conduct a formal trademark search? I don't want to overpay, and I don't want to pay too little for a cheap, lesser comprehensive search, which is why I ask.
I can't answer that definitively. I would say it could range anywhere from a few $100s to potentially a couple of $1,000s. My suggestion is find, again, through SCORE, potentially, find 2 or 3 trademark attorneys and then call them up and ask them how much their fee is. So again, do your due diligence and pick a trademark attorney that you're comfortable with, not necessarily the cheapest, but he or she might be the cheapest. But at the end of the day, you want somebody you can really trust that is going to follow up on it and can give you good advice at the very beginning. You want a person that's done a lot of trademarks to go through your name and tell you the chances of getting it trademarked, the chances of not getting it trademarked, and so forth, before you even start writing a check to them.
Okay, this was actually the person that wrote the first question. He said the first question was confused. I was asking, what are the pros and cons of actually filing a trademark with the company owning the trademark filing versus filing with my first and last name, which would make me the owner rather than my LLC. Not sure if my LLC, which I solely own and manage, owning the trademark would have more advantages if I filed with my LLC as the owner of the trademark.
And what I'm about to tell you applies to both trademarks and patents. If you put it in your own name and then your company hopefully is wildly successful and you want to sell it, then you're going to have a difficulty selling your company without that trademark or that patent being assigned to that company. So you can put it in your own name, no question. But if you have any idea of selling your company or disposing it in any other way, then you should put it in your company. My recommendation, put it in your company name. I recently dealt with a client and they wanted to change it from the personal name to the company name for that very reason. They were going to sell a company.
Was that difficult to do?
It's for a patent. I can't speak of a trademark, but you probably have to reapply for a trademark. Again, a trademark attorney is going to tell you that. But for a patent, it's somewhat straightforward. It's going to be a few $100s to do that.
Okay. How do you protect your things on social media?
I'm not sure exactly where you're going with that question.
Right. What things we're talking about, Paula?
Yeah.
It's kind of vague. So
Well, if you're going to start discussing your invention, say you invented something, and you start discussing it on Facebook, you're disclosing that. So all of a sudden, the USPTO, when you file your patent application, can go back against that Facebook page and say, you've already disclosed that.
someone feels that it wasn't appropriate for you to point out China as a bad actor. IP violations happen in all different countries, so stop trying to label one country as all things evil. I think you're not trying to do that. That was just an example.
My experience is that when you run into problems, that's where you're going to run into it. Sorry that you feel that way, but that's the way it is. That's the real world.
COVID caused a 2-year delay when I couldn't do anything. Would the USPTO give us an extension on our 20-year grant issued, as there's only 17 years left on my 20?
No.
This is the government. They're not known for their flexibility.
Well, and it's not only the government, it's in law. I mean, so
Right.
these are covered by federal statutes. So the contraction or extension of patent applications is done only on the basis of during a period of time. And if you applied for it during COVID, then they may extend it or contract it because of the delay at the USPTO. In other words, their workload didn't allow them to respond quickly enough.
All right, this is the last question so far. And it's kind of a follow-up. So if we want more control at the point, until the point of sale, best to file in our own personal name and then pay the sum to convert it, the owner, to my LLC name when.
Especially for an individual, let me call it a small business person, the answer to that is yes. It's best to not worry about your company and everything else. At the end of the day, if for example, you apply for a patent and it's granted and it's in your name and you own the company, then you can file for assignment, and that may cost you a couple of $100 or a few $100, but at the end of the day, you can do that. So if you're doing it yourself, if you're doing your provisional and or your non-provisional yourself, then I would suggest using your own name, just because it makes it easier when you go online and you file it. It's just going to make it a lot easier. You're not going to have a lot of extra paperwork.
All right. Well, thank you very much, Ralph. You, of course, did a masterful job. We're looking, if we're looking to file a trademark and a hobbyist has formed our name on Facebook with 100 likes, would that block trademarking?
I'm sorry, Diane, read that one more time.
Yes. If we are looking to file a trademark and a hobbyist has formed our name on Facebook with 100 likes, would that block trademarking? They created a Facebook business page, apparently, with, I guess, the same name.
Potentially, yes, it could. It could. If the USPTO finds out about that, they're going to say that somebody's already using that, so it's being used. But again, a trademark attorney is going to be able to answer that question better than I. I would just be very cautious of that, of using the same name. And the same thing is true, folks, for the sunbiz.org. When you look for the fictitious names on sunbiz.org, you want to find a name that is totally different than what you're seeing on sunbiz.org.
Good questions. All right. One last one, I think, also from Anonymous. They would need to sell in commerce, though, with the name for it to be a blocking factor, right? Or not necessarily. They would need to sell in
Yes,
commerce. Mhm.
probably so. Yes, absolutely.
Okay, good. I'm saying that's the last question. We are at 1:15, and I thank you so much. You have illuminated, lightened up the area for a lot of people, illuminated the area for a lot of people. So I thank you very much.
And I want to thank you, Diane. I want to thank the Manasota chapter, and I thank all the participants for listening to me for a while.
Yes, well, if you're interested in having a SCORE mentor, please don't forget score.org/Manasota. And you will be getting a follow-up email, 2 follow-up emails, actually. You'll be getting a follow-up email from our national organization, and they will be asking you your opinion of this webinar and to rate how wonderful Ralph was. And remember, it's a scale from 1 to 10, with 10 being good, not 1. 10 being the best. So a 9 or 10 is always welcome. If you're looking for a mentor, go to our website. You can search and sign up for other workshops, or search for other items that are on there, including templates. You're going to get a survey, and you're also going to be getting an email with a link to the recording of this webinar, as well as these wonderful slides. So look for those, and look for wonderful presentations like this from Ralph Warmack. We appreciate your time and talent, and look forward to perhaps seeing you at another workshop.
Thank you.
Thank you. Thank you all for coming. Bye-bye.